visit. It would certainly be worth our while. Under the early arrival rule, Senator Blackburn, you're recognized next.
Thank you, Mr. Chairman. I appreciate that. And, you know, many of us do visit prisons. And one of the things that repeatedly comes up is the number of repeat offenders and how difficult soft-on-crime policies have made it on our local law enforcement agencies in the judicial system, and also the effect of fentanyl on communities. When you look at those that are incarcerated, the number that are there because of drugs and mental health issues, those are issues we should be doing a deeper dive on. And Senator Graham mentioned how he was surprised we were taking our time today to talk about solitary confinement when we should be talking about H.R. 2, a border security bill. Number one issue with the American people right now is what is happening with that open border. Every town's a border town. Every state is a border state because of the effects of the Biden open border policy. It is all intentional. It is what they wanted. And it's what our colleagues across the aisle continue to support. Fentanyl racing into this country. We should be looking at that, Mr. Chairman. None of us want that in our communities. Look at the number of children that are being exploited by cartels that are trafficking children, and they're being trafficked into labor gangs. They're being sexually exploited. These are things that are happening, and I wish that we were putting our time into that. Now, back when I was in the House in 2007, I introduced a bill, the CLEAR Act, and it would take some of those provisions from the 287G program and give authority to local law enforcement. When they apprehend somebody that is in the country illegally, they can hold them. And then ICE has to come and ICE has to deport them and then reimburse that local law enforcement agency for what they have spent. So, Sheriff, I want to come to you, and thank you to each of you for being here today. I appreciate it. I would like to get your thoughts on legislation like the CLEAR Act that would empower local law enforcement and then have ICE deport these criminal illegal aliens and reimburse local law enforcement for what they have spent, and deny federal law enforcement funds to jurisdictions that will not comply with federal immigration law.
Senator, what you're talking about is not something new or revolutionary. We had that at one time. If I remember right, it was somewhere around
287G.
Well, even before then, even before 287G, in the 1980s and 1990s, we had officers at the Victoria Police Department who were dual commissioned as U.S. Customs agents and local police officers. And they had the authorities that you're talking about. And so the restitution of those authorities is something that can be looked at by federal authorities. And so I think that we all have to work together and do our part, because this open border that we're facing right now and the surge of transnational criminal activity is overwhelming us. I heard one of the senators early say that most of the fentanyl is being brought in by United States citizens, and that is not correct. If you lived down on the border like I am, then what you'll find is that is being brought here by transnational criminal organizations. Some of the people that work for cartels do live in the United States, but that product is being shipped here by cartel members from Mexico into the United States. They no longer are dependent on China for the precursors to make fentanyl. They have now figured out how to make it themselves. Those individuals in Mexico are some of the smartest people you'll ever meet, and they will figure out exactly what to do in order to generate a profit. And I think that we need to look at the ability to deny transnational criminal activity and organizations any ability to make profit within the United States, because I don't know if any of you have ever sat down with a Sicario before. I have on multiple occasions. When you talk about solitary confinement, as it's being called here, we call it separation in the state of Texas. Those people have to remain in separation or they will kill somebody. It's not like the movie. They're not professionals. They're sloppy and they're mean. And we have to deal with them in a manner that protects not only our correction officers, but also the fellow inmates that are in the facility, because it doesn't matter if you're a jailer or an inmate, you're made in the image of God, and I have to protect you no matter what.
Thank you, Sheriff. Thank you, Mr. Chairman.
Thank you, Senator. And Senator, in previous stage of the hearing, we had a similar request that we deal with legislation that addresses border issues. And I, for one, would like to remember that it was Senator Langford's effort that resulted in a bipartisan bill, which many of us actively supported.
Mr. Chairman, as we know, that was not a border security bill. It was an immigration bill, and H.R. 2, which is a border security bill, landed in this committee last May. Last May, the first part of May.
Let me just say, Senator.
We should have a hearing on that, whether we like it or not.
Senator.
Let's take it up and let's debate it and look at what has transpired at this border. I talk to parents every single week who have had a child impacted by fentanyl, and people that are seeing some of these labor gangs. I am terribly concerned about these 85,000 children that HHS and DHS can't find.
Well, we can go into all of these issues, and we have in the past, but I will tell you that the bipartisan effort by Senator Langford, the chosen representative of the Senate Republicans, along with Senator Murphy and Senator Sinema, was the first bipartisan effort that moved us towards 60 votes, which is essential for passage in the Senate.
And it couldn't get where it
four
needed to go.
Four Republicans, after they told us
It was
point
not
blank,
a border security
well,
bill.
I tell you, you're wrong.
And I want, well,
You're wrong,
no, sir,
Senator.
I am not wrong
And
on
HR
that. It
2
was an
received no
immigration
Democratic
bill.
votes. I don't want to go down these rabbit holes of
The American
partisan-
people are expecting us to do it. That's why they want a trial
Well,
on Mayorkas. And I think it is so wrong that Chuck
giving me-
Schumer
you're
is
gi-
trying to table
I can't
this.
keep up with all the issues you're throwing at me, Senator. We came today to talk about solitary confinement in federal prisons, and I hope we can get back to that subject. At this point, served in a variety of roles within the office and as appellate chief. He personally wrote more than 200 briefs and argued 37 federal appeals. After receiving blueslips from both Tennessee senators, Mr. Ritz was confirmed by the Senate to be U.S. Attorney for the Western District of Tennessee by a voice vote in September of 2022. In that role, he serves as the Chief Federal Law Enforcement Officer for the 22 counties of the district and supervises the other attorneys in the office. As U.S. Attorney, Mr. Ritz created the National Security and Civil Rights Unit within the criminal division of his office. He also regularly meets with and convenes law enforcement and community partners to discuss violent crime reduction efforts and other priorities. I congratulate Mr. Ritz and his family on his nomination and look forward to hearing his testimony today. Senator Blackburn is asked to make remarks, and I now recognize her for 3 minutes. Senator Blackburn.
Thank you, Mr. Chairman. Let me begin by saying just how disappointed I am that the Biden administration has once again shown little regard for the long-standing bipartisan tradition of consulting home state senators on judicial nominees. Senator Hagerty and I attempted to work in good faith with the administration. We identified highly qualified nominees to fill this vacancy, but unfortunately, the White House had other plans. It is abundantly clear that despite the White House assurances to the contrary, there was a backroom deal to appoint Mr. Ritz to this vacancy from the very start. But the most glaring example of the White House outright refusal to consult is the fact that they have not even bothered to ask what our objections to Mr. Ritz might be. Had they done so, I would have explained my serious concerns about his professional ethics, concerns that should alarm those in the White House pushing his nomination, and concerns that we have heard from many of his peers. In our country, every individual accused of a crime is entitled to due process under the law. That is a bedrock principle of justice. But that's not how Mr. Ritz has operated as a prosecutor. Mr. Ritz has been accused of using highly unethical bait-and-switch tactics to trick indigent criminal defendants into accepting plea deals they didn't agree to. And when defense attorneys pushed back, Mr. Ritz has been accused of making outright false statements to the court to cover up his misdeeds. Indeed, Mr. Ritz has chosen to surround himself with those who seemingly treat their ethical obligations with disdain. Mr. Ritz's deputy, for example, received a 1-year probation for prosecutorial misconduct. We have heard from many of his peers and colleagues. You don't have to take my word for it. Just ask Stephen Shankman, the former federal public defender for the Western District of Tennessee. Mr. Ritz has such a reputation for unethical behavior that when Mr. Shankman first heard reports of a prosecutor behaving unethically, he knew it had to be Kevin Ritz. Writing about Mr. Ritz, Mr. Shankman said, and I quote, "This is not the first, second, third, or whatever occasion that this sort of thing has occurred, but everyone should be aware of this unfortunate pattern of behavior. You should be aware, your clients should be aware, and you should proceed with extreme caution," end quote. You should proceed with extreme caution. What an admonition. Is that how the American citizen should be made to feel if they were to go into a courtroom with the presiding judge being Kevin Ritz? With an ethical record like this, I question how the ABA could give him any rating other than not qualified. He has no business representing the United States in a courtroom, let alone presiding as a judge with a lifetime appointment. But Mr. Ritz's record of unethical behavior isn't my only objection. Under his watch, as the chief federal law enforcement officer, the city of Memphis has become the most dangerous place to live in the United States. That is a fact. In 2023, Memphis had the most homicides in its history, and data shows that 2024 homicides are going to outpace 2023. Law and order has completely collapsed in Memphis under his leadership, and there is no more tragic example than last week's murder of a Memphis police officer. Officer Joseph McKinney was shot and killed on Friday by a criminal who had been arrested just weeks prior for 4 felonies, including unlawful possession of a weapon and possession of an illegal Glock switch. Make no mistake, the criminal would not have been out on the streets but for Mr. Ritz falling asleep at the wheel. His inaction has cost lives. Prior to Mr. Ritz's tenure, the U.S. Attorney's Office had a policy of charging 100% of prosecutable gun crimes. Why Mr. Ritz did not follow through on this, I do not understand. But we do know a police officer, a father, and a Memphian, they are dead because of Mr. Ritz's lack of leadership.
Senator, your time has expired.
Thank you, Mr. Chairman.
Let me say at the outset that Mr. Ritz will be before this committee for questions from all senators and have an opportunity to respond. Senator Blackburn asked for this special privilege of speaking out of turn, and I gave it to her and extended her time an additional 2 or 3 minutes in an effort to accommodate her in a fair fashion. Let me say at the outset, Mr. Ritz has been judged by the American Bar Association. To judge him and his prospective nomination, they contacted attorneys in the area as well as judges. Their conclusion, unanimously well qualified. Unanimously well qualified. If that sounds different than what you just heard, it is. Second, I want to address this notion that we have some kind of backroom deal here. The senator has been selective in talking about the facts that led to this nomination. Let me tell you the history. It takes a minute or two, but it's worth it. As many of you may know in this room, blue slips are literally blue slips of paper issued by this committee as a courtesy in order to seek input from colleagues on nominees from their home states. During the Obama administration, Senator Leahy chaired the committee and honored blue slips for both circuit and district court nominations. If a senator did not return a blue slip for a nomination from his state or her state, that individual nominee did not move forward. That was the tradition under Senator Leahy. As a result, Senate Republicans held multiple circuit seats open during the Obama administration that President Trump later filled. Both parties do that. But when Senate Democrats expressed reservations with President Trump's picks for circuit seats in their states, Senate Republicans reversed their thinking. They did away, the Republicans when they were in charge, did away with blue slips for circuit court vacancies and held hearings on 18 circuit court nominees who did not receive blue slips from their home state senators. I objected at the time, as did many of my colleagues, but we also repeatedly warned the Republicans were establishing new ground rules when it came to blue slips for circuit court judges. I've said it many times, there cannot be one set of rules for Republican nominees and another for Democratic nominees. So today and throughout this session, I am following the same standard the Senate Republicans set. Senate Republicans confirmed a nominee to the Third Circuit after the Trump White House refused to let Democratic home state senators even meet with him. Another Third Circuit nominee was informed that he would be nominated weeks before the Trump White House had a single conversation about the vacancy with Senator Casey of Pennsylvania. And the Trump White House counsel informed Senator Baldwin of Wisconsin during their very first conversation about a Seventh Circuit vacancy at the White House that they'd already selected a nominee without her knowledge. That doesn't seem like much consultation to me, but Senate Republicans said it was plenty. Given that history, the White House consulted with the Tennessee senators on this very vacancy, significantly more than precedent requires. The White House has been discussing this Senate seat with the Tennessee senators since August of 2023. They exchanged names of potential candidates in October of 2023. Mr. Ritz interviewed with members of the Tennessee senators' staffs in both October and November 2023. The White House counsel's office interviewed the Tennessee senators' suggested candidates in November of 2023. The White House then gave the Tennessee senators the opportunity to choose from 3 candidates, including Mr. Ritz. The Tennessee senators refused to do so. The White House also repeatedly offered the Tennessee senators the opportunity to interview Mr. Ritz. Senator Blackburn did not take them up on the offer until March of this year, and Senator Haggerty did not conduct an interview of Mr. Ritz until yesterday. My Democratic colleagues would have been grateful to receive such courtesy from the Trump White House. But what did Senator Blackburn offer instead? Calling this a backroom deal. Senators Blackburn and Haggerty may have preferred another individual for the vacancy, but consistent with precedent set by former Republican chairs of the committee, we will proceed with the hearing for Mr. Ritz. It's now time to call
Mr. Chairman, there are inaccuracies in your statement. I'll be happy to submit a timeline and the fact that on Christmas Eve we received an email that they were going to nominate Mr. Ritz, but I'll submit those in writing for you.
Thank you very much, Senator. First panel is Mr. Ritz, and will you please approach the table as they change the nameplates. Gretchen Carlson for being here today and inspiring a lot of the effort.
Speaking of ageless, I want to thank Senator Grassley for
what a comparison.
for helping me get this thing moving. And he's had a midlife crisis. And he's going to solve it right here in front of us, and we're going to get this bill over the line.
That is regular order for sure. We turn to the votes on nominations. The first is Kevin Ritz, nominated to the Sixth Circuit Court of Appeals. I'd like to briefly comment on his nomination. During the hearing, members of the committee questioned him about a complaint submitted to the Department of Justice Office of Professional Responsibility in connection with his representation of a case. Mr. Ritz has stated that he was not aware of the complaint, a fact he reiterated under repeated questioning by members of the committee. One member even went so far as to accuse Mr. Ritz of lying to the committee. As I mentioned yesterday, that would be a federal crime when you're under oath. No evidence was produced to suggest he was lying. In fact, this accusation was untrue, unfounded, and wholly inappropriate. Here are the facts, as Mr. Ritz explained at the hearing and as we followed up to find to be true. He did not receive notice from the Office of Professional Responsibility regarding any letter of complaint. This is presumably because OPR determined the complaint was meritless and dismissed it. As OPR itself says on its website, and I quote, "Most complaints received by OPR are determined not to warrant further review because, for example, the complaint on its face appears to be without merit or is unsupported by any evidence." This is the most important sentence. In such cases, OPR will close the matter without informing the subject attorney of the complaint. Notably, the defense attorney represented to the court during the case in question that she was not accusing Mr. Ritz of any misconduct. In fact, no allegations of misconduct against Mr. Ritz were ever substantiated. The judge in this case stated, and I quote, "The record does not reflect a determination by the court adverse in any way to Mr. Ritz. I need that to be absolutely clear," the judge said. Given these facts, the treatment of Mr. Ritz by some members of the committee was disappointing. His nomination to be U.S. Attorney was voice voted out of this committee in 2022. Notably, he enjoyed the strong support of his home state senators at the time. Does anyone seek recognition to speak on Mr. Ritz's nomination?
Mr. Chairman.
Senator Blackburn.
Thank you, and I'm not going to take up the committee's time today to rehash the White House's history of not working with Senator Hagerty and I on these judicial nominees, but I do want to say this. The White House rushed through a backroom deal to put Kevin Ritz in this seat, and by so doing, they have nominated a man whose lack of professional ethics unquestionably disqualifies him from federal judicial service. And for all of my colleagues on the other side of the aisle who care about indigent criminal defendants, who care about preserving criminal defendants' constitutional rights, and who care about supporting our federal public defenders, you should be very concerned by the prospect of Mr. Ritz serving as a federal judge. I know that my Democratic colleagues believe in the American ideal that every individual accused of a crime is entitled to due process of the law. But that's not how Kevin Ritz operates as a prosecutor. Mr. Ritz uses bait-and-switch tactics to trick indigent criminal defendants into accepting plea deals they didn't agree to. He leaves his written plea agreements intentionally vague, lures indigent criminal defendants and public defenders into an oral agreement, and then pulls the rug out from under them in court. And when a female defense attorney finally called Mr. Ritz out on his unethical conduct, he tried to defame and discredit her. In fact, Mr. Ritz was removed from that case because of his unethical behavior. The prosecutor who replaced him went so far as to say on the record that the allegations of Mr. Ritz's professional conduct, and I quote, are serious and are taken so seriously by our office that Mr. Ritz will be taken off the case, end quote. And this wasn't just one case. Mr. Ritz's reputation for unethical behavior is well known across the Tennessee bar. Just ask Stephen Shankman, the former federal public defender for the Western District of Tennessee. Mr. Ritz's ethical misdeeds are so well known that when Mr. Shankman first heard reports of a prosecutor behaving unethically, he knew it had to be Kevin Ritz. In an email warning other defense attorneys about Mr. Ritz, Mr. Shankman said, and I quote, "This is not the first, second, third, or whatever occasion that this sort of thing has occurred, but everyone should be aware of this unfortunate pattern of behavior. You should be aware, your clients should be aware, and you should proceed with extreme caution," end quote. You should proceed with extreme caution. I'd like my colleagues across the aisle to think about that one. Is that how you want indigent criminal defendants and public defenders to feel when they enter an American courtroom and Mr. Ritz is the presiding judge? I would hope you do not want that. Mr. Ritz has a history, unfortunately, of lying to the federal courts, lying to federal public defenders, and lying to indigent criminal defendants. And during his confirmation hearing, Mr. Ritz lied to the committee. Mr. Chairman, I do not believe that Mr. Ritz has the judgment or professional ethics to be a federal judge. It is deeply, deeply disappointing to me. We had asked to work with the White House. We know what has transpired here, and I hope my colleagues across the aisle who are concerned about unethical federal prosecutors trampling on defendants' constitutional rights will join me in opposing this nomination.
Thank you, Senator Blackburn. Before recognizing Senator Tillis, I would like to make this point. The committee has received many letters of support for Ritz's nomination, including members of the defense bar in Tennessee. I want my colleagues to listen to this one sentence. One letter from the federal defender of the Western District of Tennessee said of Mr. Ritz, I quote, "a fair person of integrity," and notice his, quote, "perfect temperament to serve as a judicial officer." That comes from the federal defender in Western District of Tennessee. Another letter from a criminal defense attorney who served as opposing counsel in cases with Ritz described him as, quote, "intelligent, honest, hardworking, and fair." Before we make allegations of any witness before us lying to this committee, recall that they are under oath and that would involve a possible criminal action. I would be very careful in using that term myself. Senator Tillis.
Thank you, Mr. Chair.
Senator from Tennessee.
Thank you, Mr. President. I have found this conversation so interesting. I will remind my colleagues that H.R. 2, a border security bill, actually did come to the Senate, and it has been here since May 15th of 2023, an actual border security bill. And the fact that the provisions in front of us are not border security provisions are things that are of concern. I have come to the floor to talk about the Biden administration ending a policy that we had during the Trump years, and it was familial DNA testing at the southern border. Now, they chose to end this. Nobody has benefited more from this reckless decision of the Biden administration than these cartels that are abusing and recycling minors to help illegal aliens. Yes, indeed, they are recycling children. They're recycling children who have no relationship to the adults that are bringing them in, because these illegal aliens being pushed by the cartels are attaching children to the adults so that they appear as a family unit at the border, and that will help them to get asylum. While more than 400,000 migrant children have crossed our border under this administration, reports show us that as many as 30% of those children that are DNA tested by border agents are not related to the illegal aliens who are posing as their family members. So I come to the floor to call for a motion to proceed to S 1843, the End Child Trafficking Now Act, to restore familial DNA testing at the border. The bill would criminalize child recycling. It would require DHS to deport illegal aliens who refuse a DNA test. It would mandate a maximum 10-year sentence for illegals who fabricate family ties to a minor and require HHS to process such children as unaccompanied minors. Protecting migrant children should not be controversial. But if my Democrat colleagues object, they are making their position clear on this issue. So, Mr. President, I ask unanimous consent that the Senate proceed to legislative session. Further, that the Committee on the Judiciary be discharged from further consideration of S 1843 and the Senate proceed to its immediate consideration.
Is there objection?
Reserving the right to object. Mr. President,
Senator from Illinois.
I understand this bill is intended to, quote, require a DNA test to determine the relationship between asylum-seeking adults at the border and, quote, any accompanying children. However, it fails to accomplish this goal, and our current laws already include provisions to allow for DNA testing. Under current law as written, DHS and the State Department already have the necessary authority to collect DNA where there's any question about the familial relationship between a non-citizen and a minor child traveling with them. At the southwest border, the Department of Homeland Security currently conducts DNA testing when there's any question about the validity of the parent-child relationship, and additional scrutiny is placed on individuals who are not related to the child to ensure that a child is not being trafficked. Due to what I assume is a drafting error in this proposal before us, I have to note that this bill would not even apply to families seeking asylum at the border. As it is currently written, this bill only applies to someone who is, quote, admitted, close quote, to the United States. But under our immigration laws, asylum seekers at the border, quote, enter, close quote, the United States, but are not usually, quote, admitted. There's a big distinction here. That means that this bill would apply to any non-citizen family coming to the United States through our legal immigration system, but not families crossing the border to claim asylum. Exactly the opposite of what the senator says that she wanted to achieve. The family relationship of those who are coming to our country through the legal immigration system are usually validated by multiple agencies before applicants are issued a visa. For example, assume a family from Mexico wanted to come to Disneyland in Florida and apply for a visitor's visa for that purpose for themselves and their children. They would need to prove at the airport under this bill that they are the relatives or guardian of the children or submit to a DNA test. Is that what we're going to expend our energy on? If the family refuses, the adults may be arrested, the children will be treated as unaccompanied children and placed in custody. Is that what we want to achieve? This bill would require every such family to prove their relationship with their children at the airport or other ports of entry. The burdensome requirements in this bill would bring our system for processing lawful travelers to a halt and deter legitimate trade and tourism in the United States. As a senator from Tennessee knows, protecting kids has been one of our top priorities in the Judiciary Committee. Last year, we held 2 hearings on safety and well-being of children seeking refuge in the United States. We heard from child trafficking experts and government witnesses. Following up on these hearings, the committee is in the midst of an ongoing investigation of the issue. We all agree that no child should be abused, exploited, or trafficked, whether the president's a Republican or a Democrat. I vigorously oppose the Trump administration's inhumane family separation policy, and I've demanded that the Biden administration do more to protect migrant children. It's easy to criticize the executive branch, but let's take a look at the reality of the situation. We need to look in the mirror. It has been decades, over 30 years, since Congress passed meaningful immigration legislation. In less than an hour, at 2 o'clock, every senator, Republican and Democrat, will have a chance to make history, to start us on a conversation, a bipartisan conversation for a better immigration system. Instead of lobbying partisan attacks, let's come together across the aisle to fix the broken immigration system. We should provide funding for enforcement against child labor violations and ensure child migrants have the services they deserve. I've introduced legislation to improve sponsor vetting and placement, help children navigate our legal system, and better protect minors in government custody. I welcome my colleagues from either side of the aisle to join me. I'd be more than happy to sit down with any of my colleagues to discuss solutions that would prevent child trafficking. Sadly, this bill does not accomplish that goal at all. I object.
President.
The objection is heard. The senator from Tennessee.
Thank you, Mr. President. I think that the esteemed chairman of the Judiciary Committee is misreading the bill, because this would apply to people that are entering the United States. It would apply to those that are coming to the southern border. And this is a process that had been in place. The Biden administration chose to stop this process. Mr. President, what we understand is they chose to stop this because the test takes 45 minutes to determine if that child is or is not related. 45 minutes to determine if that child should be left with those adults. And 30% of the children that are DNA tested at that southern border are found to not be related to the adult who is holding them by the hand, who is bringing them in the country. So I would ask my colleagues, is 45 minutes too much time to take to be sure that a child is secure? We have had 10 million people come to that border. We have had 400,000 of those children. Don't we want to provide the best for these children and separate them from traffickers? And by the way, HHS has lost track of 85,000 of these children. They can't tell your committee, Mr. President, where those children are. They can't tell Judiciary Committee where those children are. 85,000 children. We do not know if they are dead or alive. We do not know if they are being labor trafficked, sex trafficked. We do not know what is happening. DNA testing is a way to help save some of these children. We should return to this policy. And by the way, again, I will mention H.R. 2 has been in here. Homeland Security Committee has had 374 days to have a markup on a border security bill. They chose not to. Judiciary Committee could have had a markup on a border security bill. They did not do it. But they're bringing a political stunt bill to the floor today to try to push it through to give cover to vulnerable members of your party. Yield the floor.